Ladies and gentlemen, distinguished guests, it is my privilege and honor to welcome you to this edition of Talking Disputes. I'm happy that we are so numerous in the room. I'm even happier that we are even more numerous online. I'm looking forward to what I hope will be an interesting discussion of this case. As you all know, we are discussing today the Appellate Body report in India Agricultural Products, an SPS case that walks through a whole range of issues that SPS inclined lawyers find exciting, and probably also SPS applying and receiving countries find exciting, or at least interesting. My name is Hannes Schlömann. I'm a director of WTI Advisors. Together with ICTSD, the International Center for Trade and Sustainable Development, we have the pleasure to run this series. It's an idea that once came up and has taken its place in the landscape in Geneva. So we're very happy to have you all here. Talking Disputes is designed as a discussion event. So what we don't do is talk for 2 hours and then have 5 minutes of questions. You're invited to ask, but also to comment if you like. The discussion with you being here in the room and you being online, is very much part of what this is about. The format is straightforward. We have one speaker who introduces the case and the findings to us. Then we have 1, 2, or 3 commentators. Today we have 2. I'll introduce them in a second. Then we're all invited to be part of the discussion. Before I forget, there are 2 things that we absolutely have to keep in mind. The first one is our gratitude towards the mission of Finland for having kindly lent its decisive support to making this event happen here and today. And the second one is the feedback forms that you have in front of you are important tools for us to get better and better. So please do take a moment to just give us your feedback. You can, of course, also do it in other forms, but experience suggests that the form is a good tool to do that. So please, by all means, fill them out if you can. As I said before, this event is web streamed live. That's something that we started doing recently, and we're looking forward to the participation of the people who are not in Geneva. It is part of the ambition of this event to carry this discussion of disputes at the WTO, this demystification exercise, not only into the Geneva community, but also to the outside world. I know that people are tuning in from quite far away. The online community is also invited to submit questions and comments, and we will integrate them into our discussion here. Let me quickly introduce our speakers today. Our first speaker is Eugenia Costanza Laurenza. She is a senior associate at Frattini Vergano, European Lawyers, a very prestigious firm in Brussels, where she deals with EU and international trade law. Eugenia has been involved in a variety of projects on EU and WTO law. She's working on market access, as trade lawyers do, sanitary and phytosanitary measures. That's what makes her so suitable for today's event. TBT, of course, as well. One rarely goes without the other. She advises governments and a range of other clients, of course, also private operators, on a lot of things related to trade, including, not least, negotiations in goods, services, and investments. She's also been involved in litigation before EU courts and WTO bodies. She will provide the overview of the key findings and therefore has a little bit more time than the others. She will be followed by Alessandra Arcuri. She's associate professor to my far left, associate professor of law and economics and international economic law at the, I believe, the Erasmus University in Rotterdam. I hope I got that right. She is teaching on trade law and economics in various places, has gone as far as Togo and Italy. Italy is where she's from. And researches obviously also in these areas. She is what we call internally the legal commentator today. To my right is Professor Susanna Sternberg-Leverin. Is that how you pronounce it? From Sweden, I believe. Is that correct? She's an expert in the field of monitoring, prevention, and control of infectious animal diseases, epidemiology of infections, and biosecurity. In other words, she knows what lawyers only pretend to know. So we will all be very silent at that point when she speaks and finally understand the things that we always thought we did understand. Her research covers several aspects of infectious animal diseases. Prior to her work at the Swedish University of Agricultural Sciences, she served as deputy state epizoologist at the National Veterinary Institute in Sweden, and she's also been the chair of the subgroup on tuberculosis of the EU Commission Task Force on Disease Eradication Programs from 2006 to 2014, and she's a member of the EU Veterinary Contingency Team. That, I hope, makes you all sit back in awe and expect some important and quite elucidating comments. One of the things that is at the center today is AI. Those of you who have seen Matrix know that AI stands for avian influenza, not artificial intelligence today. Although I was struck by the fact that one of the key documents in this case is something called the terrestrial code, which suggests that we may not be too far away from some esoteric questions here. Let me now invite Eugenia to start and elucidate us on the case. Thank you very much.
Thank you, Hannes, for this introduction. I hope everybody can hear me well. I have the very difficult task of trying to summarize this report in 15 minutes, so I will start, and we're happy to take any question after. And I will be very mindful of the time. So I'm going to make a presentation on the general findings of this case. My presentation is going to I'm going to consider the background of the case and an overview of the key findings of the appellate body. Not all findings, but the key ones. So as a first introduction, what is at stake in this dispute? This dispute concerns import prohibitions imposed by India since 2011 on a variety of agricultural products because of concerns related to avian influenza. Now, avian influenza, AI, is an infectious disease, as many of you know, which is found usually in wild waterfowl, such as ducks and geese, and which can sometimes spread to domestic poultry and cause large-scale outbreaks. Avian influenzas are the types, let's say, of avian influenza are classified according to their pathogenicity, that is, the ability to cause disease in birds, into two broad categories: highly pathogenic avian influenza and low pathogenicity avian influenza. The Animal Health Organization is the OIE, which is the standard setting organization and looks at animal health and zoonosis, requires its members, including the US and India, to notify any occurrence of both highly pathogenic avian influenza and certain types of low pathogenic avian influenza in their territories. What is the measure at issue in this dispute? India's measures are those that prohibit the importation of various agricultural products into India from those countries that reported notifiable avian influenza, so NIE, maintained through two main acts: the Indian Livestock Importation Act of 1898, as amended in 2001, and the Statutory Order 1663, which was issued in 2011. The first instrument is the instrument that empowers the central government to regulate, restrict, and prohibit, as the government seems fit, the import into India of the livestock, which may be liable to be affected by infectious or contagious diseases. And the statutory order was in fact issued in the exercise of this power in July 2011, and it imposed an import prohibition on 10 categories of products from countries reporting cases of notifiable avian influenza, both highly pathogenic avian influenza and low pathogenic avian influenza. At the outset, highly pathogenic avian influenza is extremely infectious and can be highly lethal to poultry, whereas poultry infected with low pathogenicity notifiable avian influenza exhibit little sign of illness. The measures that are relevant to disputes are those included in the SPS agreement. I'm sure that many of you are, if not all, familiar with the agreement. The SPS agreement provides for a number of core obligations. Among them, in particular, members are the obligations that require members to base their sanitary and phytosanitary measures on scientific principles and not maintain them without scientific justification. Obligation to base the measures on risk assessment. There is an obligation to harmonize the SPS measures to the international standards where they exist, and the International Standard Setting Organization recognized for the purposes of animal health measures is squarely the OIE. And also the obligation to adapt SPS measure to the regional conditions. So these are the main obligations that were at stake in this dispute. The US challenged India's measures in 2012 and raising a number of claims of inconsistency with these measures. Inter alia, the US claimed that India's measures were not based on scientific principles and were not maintained with sufficient scientific justification. The US also claimed that India's measures were not based on the relevant international standards set by the OIE, which is in fact contained in the Terrestrial Code, Chapter 10.4. The US claimed that India's measures were not adapted to the SPS characteristic of the area from which US export originated, and that India's measures were more trade restrictive than required to achieve India's appropriate level of protection, and so they were overly restrictive and unnecessary. The panel report was issued in late 2014, October, if I'm not mistaken, and the panel mainly sided with the bulk of the U.S. Allegations, mainly sided with the U.S. Claims, and found a number of inconsistencies. In particular, the panel found that India's measures did not conform to the relevant international standard, and therefore India did not benefit from the presumption of consistency. India's defense, basically in the first stage of the dispute, hinged on the fact that, according to India's interpretation of the OIE, its measures did, in fact, conform to or were based on the relevant international standard. But the panel did not side with India's agreement, and the panel also found that India's measures were not maintained that India fell short of its obligation to base its measure on a risk assessment. In addition, the panel also found that India's measures were more trade restrictive than required to achieve the appropriate level of protection, and that India fell short of its obligation on Article 6. They don't recognize in particular the concept of disease-free areas and areas of low disease prevalence. There are four core aspects that were treated in the appellate body. These are not all substantive aspects. I've just wanted to focus on the ones that I thought were most interesting and of most relevance for the discussions. the scientific basis and risk assessment, and in particular the relationship between Article 2.2 and Article 5.1 and 5.2 of the SPS agreement, which relate to the obligation of risk assessment and to base the measures on scientific principle. The compliance of India's measures with international standard, which in the appeal stage was an issue that related to the use of experts from the relevant international organization in WTO disputes, the application of the provision on regionalization, Article 6, and the trade restrictiveness of India's measures and the appropriate level of protection. With respect to the relationship between Article 5.1 and Article 5.2 and Article 2.2 of the SPS agreement, as I said before, these obligations, basically, the Article 5.1 requires countries to base the measures on a risk assessment. Article 2.2 sets the general principle that SPS measures shall not be maintained without sufficient scientific justification and shall be based on scientific principles. So the panel found a violation of Article 2.2 as a consequence of the inconsistency of India's measures with Article 5.1 and 5.2. And based on the understanding of the relationship between the two articles. As I said, India based the large part of its defense before the panel on the fact that its measures did comply with the international standard. But its measures were not found to comply with international standards, and so therefore its measures were also found not to be based on a risk assessment. Therefore, the panel also found a violation of Article 2.2. And this was based on previous case law, according to which a violation of Article 2.2 can be presumed when, in cases in which there is a violation of Article 5.1, that is, a lack of a risk assessment can be presumed also to lead to an inconsistency with respect to the principle that measure must be based on scientific principles and shall not be maintained without scientific evidence. The appellate body, in this respect, and I think that the following speaker will elaborate a little bit more on this point, did acknowledge the past case law, but it did basically find that the presumption was rebuttable, and that in that case specifically, the panel failed to take into consideration the evidence that India brought with respect to two specific categories of measure, fresh poultry meat and eggs. In particular, the appellate body did confirm that the presumption that there is a relationship, that there's a very close relationship between these two provisions, but also said that a violation of Article 2.2 cannot be inferred in all cases. However, the appellate body did also say that establishing that there exists a rational or objective, well, sorry, just a step back. The appellate body went to look at the case law, and it did find that there is a presumption of inconsistency of Article 2.2 whenever there is a violation of Article 5.1. But it also highlighted that Article 2.2 requires the existence of a rational relationship between the measure and that is the SPS measure that is applied, and the scientific principles underlying it. So basically, and I will leave then this point to the other speaker, the appellate body note, yes, that the presumption is rebuttable, but it also said that there exists a rational relationship between the SPS measure and scientific evidence for purposes of Article 2.2, and it will be very difficult in most cases to demonstrate this relationship. It's a bit complicated. It would be most difficult without a member demonstrating that such measure is based on assessment of the risk. In practical terms, the appellate body said that although the presumption is rebuttable, it is in fact practically difficult to have a case in which there is a violation of Article 5.1 but not a violation of Article 2.2. So in this case, the appellate body did confirm that the presumption exists. It confirmed its past case law. It also said the presumption is rebuttable, but in the specific case, it did revert the panel's findings with relation to two product categories for which India had presented evidence that its measures were indeed based on the scientific principles, but this evidence was not considered by the panel at the first stage. Oh, this was already for the other slide. The following claim concerned the compliance of India's measures with international standard. The panel had concluded that India's measures were inconsistent with Article 3.1, that is, India's measures were not based on an international standard, and therefore India was not entitled to benefit from the presumption of consistency, which follows from Article 3.2. In practical terms, if a member or conforms to, if a member conforms to an international standard, the measure is presumed to be WTO consistent. So because the panel concluded that India's measures were inconsistent with the Article 3.1, it also concluded that India did not benefit from the presumption of consistency. In this particular claim, in its challenge, actually, India, in this leg of the challenge, India actually appealed the panel's findings of inconsistency with Article 3.1 in relation to two points. According to India, the panel exceeded the permissible scope of consultation with the OIE, and this was not in line with Article 11.2 of the SPS agreement and Article 13.2 of the DSU, which set the rules in relation to the possibility of panels to seek external expertise. And also, according to India, because of this, the panel failed to make an objective assessment regarding in fact, the interpretation of the OIE code. So India's challenge with respect to this part was mainly procedural. In relevant part, the appellate body analyzed the said provisions of the DSU and the SPS agreement and concluded that India's reading of such provision, that is, that only scientific or technical questions should be posed to experts and not interpretative questions, was not in line with the provision at stake. The panel in the first stage, in order to understand if India's measures conformed or not to the OIE terrestrial code, invited and posed questions to experts from the OIE, that is the very organization that is in charge of developing such standards. So the appellate body did not consider that the mentioned provisions, specifically the provision of Article 11 of the SPS agreement, did in fact limit the panel's liberty and discretion to invite experts and to pose them questions that were not technically, not only scientific or technical, but it also said that in any case, SPS cases are scientific and technical in nature. So the appellate body did not consider basically that these provisions impose constraints on a panel's consultation with relevant experts. And it stated that it did not consider that there be any basis for understanding provisions as limiting the permissible scope of the panel's consultations with an international organization on technical issues. And the second claim was also dismissed because the appellate body basically did say that the panel, although it did invite and obviously took into consideration the view of the experts from the organization, which is the very organization recognized as standard setting, nevertheless, the panel did make its own assessment and so did not fall short of its obligation under the DSU to make an objective assessment of the facts of the case. So basically, here the appellate body also confirmed that India's measures did violate Article 3.1 and did not benefit from the presumption of consistency under Article 3.2. Is this not? Oh, sorry. Another claim related to the adaptation to regional condition. The panel found that India's avian influenza measure to be inconsistent with Article 6.2 and 6.1 because they did not recognize the concept of disease-free areas and areas of low disease prevalence, and because they were not adapted to the regional conditions, SPS characteristic of these areas. India's appeal specifically challenged the panel's understanding of the relationship between Article 6.1 and 6.3 and Article 6.1 and the other two paragraphs of Article 6. According to India, an importing member's obligation to adapt its measure to the regional condition of the country from which it imports arises only after an exporting member has made a proposal, has made a claim under Article 6.3. In relevant part, the appellate body took this opportunity, and this is one of the most interesting aspects of the case, to provide an explanation of Article 6 as a whole and the relationship between the three paragraphs, and made a number of observations. In relevant part, the appellate body found that the paragraphs of Article 6 to be interconnected, and that Article 6.1 is the article that provides for the overarching obligation of members to adapt their SPS measures to the regional conditions of the members from which they import the measures in relevant part. They import the products in relevant part, and they also found that the provisions in Article 6.2 and 6.3 are in fact specific characterization of this overarching obligation. The other paragraphs, in fact, are elaborate on the specific aspects of the obligation with respect to pest or disease-free areas and the duties that have to apply to an importing and exporting member. The appellate body, in relevant part, found that the obligation of adaptation of an importing member is a continuous obligation and is not contingent upon whether an exporting member has made an objective demonstration of its regional conditions. In this case, area of low prevalence, of low disease prevalence. The appellate body did not affect the panel's overall, the appellate body's view, of course, did not affect the panel overall conclusion with respect to relationship between Article 6.1 and 6.3, that the obligation of Article 6.1 is not triggered by an invocation of Article 6.3. But they did make a number of relevant points and qualified the panel's first analysis of this provision. Finally, the last substantive claim that I want to give an overview on relates to the trade restrictivist characterization of India's measures. Again, India appealed the panel's findings that the US had identified a less trade restrictive alternative measure that could achieve India's appropriate level of protection. Basically, in the context of this dispute, the appellate body recalled what is the standard of review of Article 5.6 and Article 2.2. The appellate body recalled that to succeed in a claim under this obligation, I take it to 2.2 to recall that Article 5.2 requires members to not impose measures which are more trade restrictive than the necessary to achieve the appropriate level of protection, taking into account technical feasibility. And so to succeed in a claim under this standard, a complainant, the appellate body recalled, must establish that there is an alternative measure that is reasonably available, taking into consideration technical and economic feasibility, that achieves the member's appropriate level of protection, and that is less trade restrictive than necessary to achieve such appropriate level of protection. The panel's findings of inconsistency with Article 5.2 and 5.6 and Article 2.2 on these three findings rested on basically the finding that measures based on the recommendation of the OIE would be technically, economically feasible as a reasonable alternative measure to India. The US did identify an alternative measure that would achieve India's appropriate level of protection, that is the measures of the OIE, and the proposed alternatives would be less trade restrictive than India's measures, which basically amounted to import bans, countrywide import bans. So India challenged, in particular, with respect to this claim, that the US had identified India's appropriate level of protection. In particular, and by not doing that, and by failing the US to identify India's appropriate level of protection, the US, according to India, fell short of its obligation to prove that an alternative measure, in fact, existed for India to achieve its appropriate level of protection. In practical terms, the appellate body dismissed India's claim. This part of the dispute was particularly interesting in as much as the US found that the appropriate level of protection in the exercise of its complaint, the US found that the appropriate level of protection of India was very low because it tailored it to India's domestic measures, whereas instead the panel made its own assessment of the appropriate level of protection and find that the standard to be instead very high. In practical terms, the appellate body dismissed India's challenge, and it did state that the fact that the US did not identify the appropriate level of protection did not basically have an effect on the fact that there was a violation of Article 5.6 and did not basically have an effect on the finding of the panel. And by the way, the panel's finding was based on the panel's own appropriate level of protection, which was not the one of the US. well, this I've already said. I just wanted to provide I hope that I'm in time to have a... Just a couple of comments before setting the stage for more detailed discussions on specific points. I find that, well, as other commentators, and perhaps I'm not being very original here, have found, I think the interesting aspects of this dispute are the findings in relation to the relationship between Article 2.2 and 5.152 and the rebuttability of the presumption, and yet the finding that it would still be difficult to find a violation of not finding a violation of Article 2.2 in presence of a violation of Article 5.1. The use of experts and the fact in disputes, and the fact that the panel's ability to seek external expertise is not limited to technical and scientific issues, and that panels enjoy leeway in the resort to this in recourse to external advice, especially if it's from organizations that are relevant for the dispute at stake. Like in this case, the experts called were precisely those of the organization that developed the standards that the panel sought to interpret. And also the other interesting aspect is, of course, the one relating to Article 6 and the fact that this case gave the possibility to the appellate body to make an assessment of Article 6 and basically set the relationship between the various provisions of Article 6. Another interesting aspect is the appropriate level of protection. At the appellate body stage, the matter there was mainly procedural, but still it was an interesting aspect of this case. I think I have no further comment at this stage, and thank you for your attention, and I hope I didn't speak too fast. Thank you.
Thank you very much, Eugenia. Thank you very much for this tour de force through the findings. Some points more loyally than others, I suspect. One of the questions that I have is how relevant is that distinction or that relationship between Article 2.2 on the one hand and 5.1 and 5.2 on the other hand for people outside of the pure legal and legalistic community? In other words, how relevant could that possibly be? I haven't found the answer yet, but that's also because I haven't thought about it perhaps thoroughly enough. So Alessandra, if you do have answers to that, please go ahead, although I think there are also other interesting aspects that we might focus on. Alessandra, you have the floor.
Thank you. Well, first of all, let me take this opportunity to thank the ICTSD for having invited me. It's really a pleasure and an honor to be a speaker in this set of interesting event, and I think very stimulating. So also chapeau to this initiative that you have taken. I think it's very important that disputes are talked through. Having said that, I also feel that this is a little bit incestuous because I'm going to comment on WTO law within the WTO, but is as incestuous as exciting. So also something about my qualities. I was invited as legal commentators, but I'm also an old-fashioned academic. So I tend to also breach the boundaries between law and other disciplines, and I see also my contribution as being this, to go a little bit beyond the legalistic and to the really what, in my view, is the essence of the SPS. So let me start with presenting the focus of my comment that is on the standard of review. So basically in relation to how much deference is paid to the bodies that take decisions, in this particular decision relating to risk regulation. And I also identified as the interesting aspects, or at least the one I felt most comfortable to comment on, is the relationship between 2.2 5.1. So it's a good just continuation and hopefully part of an answer to Hannes' question. Then just a very quick note on the determination of the appropriate level of protection, so the ELOP, and on regionalization. I understood also some of you are interested on that. In relation to the first point, I think the basic has already been mentioned. As you see in the title of my slide, I see this as Science 2.2. I put this Science 2.2 because I see that potentially here is the creation of a new category. And let me illustrate this better. So I claim there is a new jurisprudential term because in the past we have in easy hormones and in Australia salmon has been asserted the presumption of inconsistency when you violate 5.1 presumption of inconsistency with 2.2. What is new here is that the presumption is rebuttable. So the appellate body says these articles are closely related but different. There are two categories here. And what is the reasoning behind that? Is on the basis of the principle of effectiveness in treaty interpretation. So, in other words, if there is part of a treaty that indicates something, if we just reduce to nothing, this violates principle of interpretation in international law. Now, some of you may recall that a similar issue emerged in relation to another relation, the one between 3.3 and 5.1. And whereas there it's just reduced, so there is scientific justification or risk assessment, and that the appellate body said these are the same thing, also playing a little bit with the footnote on that article. And some scholars, including myself, did criticize that as violating the principle of effectiveness in treaty interpretation. So I'm happy to see it here that there is a distinction. However, this distinction has some ambiguities. On the one hand, it's clear that when there is a justification of an SPS measure on scientific basis that are different from risk assessment, this is brought into the realm of arguable. But is it really possible? In the appellate body report, we see two answers. On the one hand, what Eugenia was just saying, well, yes, but it's basically almost impossible to rebut. Of course, phrased more diplomatically in paragraph 5.29. However, the appellate body has really identified a real space there because it says, well, the panel erred in finding a violation of Article 2.2 in relation to the products for which Indian adduced evidence to show that the measures were based on scientific principle. So basically it says, look, you erred because you didn't assess that piece of scientific evidence. And where do we find even a list of what could potentially be part of this space of Science 2.2 is in the footnote 353, where there is a number of studies. Interesting, some of these studies are just the same that have been presented by the US or of the same author by US and India. But in any event, if the appellate body writes in a footnote that these are the studies that the panel should have assessed, so these are the evidence, well, it does, at least conceptually and to some extent practically, identify this space for 2.2. But, Hannes, you are right in a sense, because Science 2.2 seems of little use. Why? Because of the applicability. So if, well, even if you show compliance with this, which is very difficult, but we said maybe you can manage to, still a violation of 5.1, sorry, there is a mistake in the slides, determine the incompatibility with the SPS agreement. So we do have a problem. And I think here we have actually a paradox, because if analytically the appellate body says Science 2.2 exists as a distinguished category from risk assessment 5.1, and then it tells me, yes, but it tells us a measure found to be based on scientific principle may still violate the SPS agreement irrespective of its discriminatory nature. My question is this problematic? And I think it could be. Why? Because Article 2 is basic rights and obligation. So if you establish that there is a right to base your SPS measure on Science 2.2, now you're saying, well, actually this right is ineffective. You cannot use this right. So I think if you establish a conceptual category, then there is an inconsistency here. Again, depending on how you think the SPS agreement should be interpreted, in any case, there is a little bit of a paradox. So, very fascinating part of the report. second comment is on the ELOP. What do we find? It's already been summarized. So the idea here is that there seems to be a mix of deference because the panel or the judiciary body should take into account what is brought up by a member, but should not be completely differential. So you should look at the totality of arguments. Even more, the appellate body says the ultimate aim in the end is to determine whether less trade restrictive measure exists. So what we are really interested in is the comparison. Now, this has been already noted in a blog post by Professor Cho, that this seems to be an approach less differential than the appellate body has done in the past. In particular, the reference goes to the easy hormones case, where the appellate body accepted even different levels of protection. Even more, let me add to that, there was also a discussion on the obligations of consistencies under paragraph 213 of the hormones case, where there is no legal obligations of consistency of the ELOP. The goal of consistency is not absolute, or perfect consistency is not demanded. So in that sense, I do see the point made by Professor Cho. On the other hand, we see that let us have a look of how in practice the ELOP was determined. And we see that India makes two claims. What is this ELOP? Is the prevention of ingress of HELP9 and HPNI. This is also one of these reports full of acronyms, very difficult to pronounce, but I hope I pronounce it good. And the second argument made by India is our ELOP is a country freedom from notified avian influenza. On both claims, the panel says, well, no, this is not realistic. In the first, you cannot possibly reach a zero risk, and in the second, it's really just not realistic to have this freedom from avian influenza. So it seems to basically reject what India is presenting as its ELOP, so having an intrusive approach if we look from the standard of review perspective. At the same time, the panel accept the very high level of protection. And the appellate body seems to agree with the panel on this, that it took the right approach. But in my reading of the case, this criterion is very vague, because what is a very high level of protection? What I'm afraid is that the risk of conflating non-discriminatory analysis with the assessment of ELOP and ending up in a circular reasoning, or having in mind the standards that are internationally set, and that's it. So it's just, I don't see how in practice, really, what in practice meant this part of the report. And with this, I come to my third, to the analysis of the third part of the report that I find interesting, that is about regionalization. Again, Eugenia has presented you with the broad picture. My view of the appellate body report here is that it is sort of a contained upholding of the panel findings, because there is a number of passages where the appellate body disagrees with the panel. And I give you some examples. It starts by saying some statements of the panel are overly broad, and then it's further specify. What is oops, sorry. So that's what I just said. It did focus on this relationship. So this was one of the central elements, and that's interesting because it's one of the first time that this is being interpreted. So the panel say that the Article 6.1 is a freestanding obligation, and the appellate body sort of tames it down. It says, yet there are important interlinkages among the different paragraphs. This is a continuing obligation, and so on and so forth. And when it moves, because the critical point was India said 6.3 is the triggering factor. So it's the exporting member that has to first tell us we have this zone that is pest-free, and then the ball is on you. But if you don't have this triggering factor 6.3, then we cannot move on 6.1. And it lost both, but look what the appellate body said in paragraph 105.7. It says, we agree with the panel that the obligations in 6.1 and 6.2 are not triggered by the invocation of Article 6.3. But then it says, we understand the relationship of Article 6.3 with the reminder of Article 6 to mean that an exporting member claiming that an importing member has failed to determine a specific area within that exporting member's territory as pest or disease-free and ultimate adapt its SPS measures to that area will have difficulties in succeeding in a claim that the importing member has thereby acted inconsistently with 6.1 and 6.2 unless that exporting member can demonstrate its own compliance with 6.3. So it seems something of compliance by the exporting member with 6.3 is a rebuttable presumption. It's here you see also that there is some ambiguities. Another interesting dimension of the report on this is that the appellate body agreed it's important that there is recognition under 6.2 of pest-free areas. But there is little guidance on saying what does it mean, recognition. So it's not an implementing act. What does it mean? It's not what India is currently doing, so having a vague option in its original old law. But actually earlier in the report, again, what I find fascinating that often in footnotes you find very interesting information. The appellate body gives an example by which a member could recognize under 6.2 these pest-free areas, and it says this would be the case, for example, where a member has established a mechanism for recognition of pest and disease-free areas, and areas of low pest and disease prevalence upon a properly substantiated request being made by an exporting member seeking such recognition and allowing verification of the same. So it says if there would be a mechanism, let's say, I don't know, an administrative mechanism in the law, probably that would enable a member to comply with 6.2. So this also could mean that India, by enacting such a mechanism, would comply with the provisions of Article 6. Now, some comments on that. Regionalization, interpretation of 6 as an half empty glass. The main insights of this part of the report is that these paragraphs are interlinked, but it remains somewhat fuzzy the role of the exporting member. What should the exporting member do? The assessment we read that should be done on a case-by-case basis, etc. What I'm missing, for instance, is consideration of Annex A6, where there is a definition of a pest or disease-free area, that is an area whether all of a country, part of a country, all parts of several countries, as identified by the competent authorities, in a specific pest or disease does not occur. So in the text of the SPS agreement, actually there is a reference to the competent authorities, which arguably are the one of the exporting country. At the same time, I see this as a half-full glass, because the appellate body approach, to me, it seems somewhat compromised. Let me put everything here. So, on the one hand, it recognizes some general obligations of the importing member to have some sort of mechanisms that has some degree of detail in the law, so say we are ready basically to accept it and should probably specify the conditions. On the other hand, is also give weight to the role of the exporting member, just with the passage I quoted a minute ago. And I also was looking at the guidelines for further practical implementation of Article 6 adopted by the SPS committee. So I know that there are some SPS committee members. You are more familiar than me with this guideline. And I do see this as partly maybe reflecting the appellate body interpretation, reflecting some of these guidelines, where you see that the importing members should publish the basis for the recognition of pest or disease-free areas. And then you have different steps, and the first step is the exporting member requests information about procedures or recognition. So in other words, I do see this article as really setting a sort of relational obligations. And I conclude, as I see our chair looking nervously at me. So a final note, I didn't discuss some relevant issues that were touched already by Eugenia, the question of international standards and experts. I think that was also an interesting part of the report. How do you interpret international standards? Which raise other questions. What are these international standards? What is the nature? Is law? And that would trigger also the answer who is best up to interpret these standards. The other question, I think that a lot of the factuals that we didn't discuss, for instance, to assess the discrimination and so on and so forth, is again based on facts. So experts are quite crucial to advise the panel. And I was looking at these experts, and I saw that most are also have strong links with the OEA or OIE. Depending whether we endorse the French or the English pronunciation. But so I was wondering what is, I'm sorry, I don't have the screen very close, so I apologize if I don't, if you don't have on screen everything. But so this fact that these experts that have assessed other questions have strong links with the OIE made me ask the question, what is the role for developing countries in this organization? Because I'm not an expert of this organization, but I've studied a little bit the codex, and there have been issue of developing countries being marginalized. ISO is the same story. So again, when these standards play such a fundamental role, I think this again triggered this type of question. And I think here also the perspective of science and technology studies is important, that view science not just as this given objective concept, but something that is constructed where interests play a role. So again, if one accepts this vision of science, it means we should become more sensitive to the institutions that determine the scientific standards. And overall, the last question is, probably on several points, the appellate body did a terrific job, but that nevertheless seems that there is a rather strict standards of review. And is this problematic when we consider that the respondent is a developing country? And I think with this question for you, I close my speech.
Thank you very much, Alessandra. In fact, I remember that on one talking dispute here not too long ago, we actually had that precise question exposed by, I believe, an Indian speaker who was speaking quite long before this case came up about the practical challenges and actually jumping through all these hoops. I think that's an important, certainly an important thing to be kept in mind. Of course, the role of committee guidelines and committee recommendations, committee decisions is something that is of high interest presently in this House, not least because the TBT committee is also grappling with that challenge. And I like your ambition, and I hope I think you got pretty far on that way to guide us into the essence of the SPS agreement. Even more close to the essence, I suspect, is what Susanna is going to tell us now. And I recall your comments on the role of experts in this matter and in other matters. When we deal with things like science in law, we often have that phenomenon that the lawyers somehow try to encapsulate what these other factual things somehow mean in order to quickly move towards the legal assessment. And my impression as a lawyer is that we are often best advised to remain very silent for a while and actually listen to the complexities that are before us before returning back to the role of that the law imposes on all of us, not just lawyers, to come to certain conclusions in the real world where, what did the appellate body say, where people live and work and die. I always thought why they say work in the middle. Anyway, this is work, so Susanna, you have the floor. Thank you very much for being here.
Thank you very much for inviting me. I will move to a different aspect of this, and if I say things you already know, then just relax and sit back, and if I say things you don't know, then perhaps you will benefit from me saying that. It's already been touched upon that avian influenza virus is divided into HPA and LPAI. We're talking about avian influenza viruses as age 5 and age 7. Influenza viruses are designated age and N, and then a set of numbers after that. There are several combinations of that, up to 144. But the ones we're interested in here are age 5 and age 7, because those are the ones that can be found in high pathogenicity avian influenza viruses. So far, we've only found age 5 and age 7 in those. So it's strictly those that are included in the general sort of global surveillance and in the OIE code. And the OIE code also only deals with these in poultry. I'll get back to that. So these shortages, if there's an N in there, it's just to clarify that it's notifiable, but it's still avian influenza and it's notifiable, and we're still just talking about age 5 and age 7. So the high pathogenicity avian influenza viruses are what we're worried about, and they cause serious disease in poultry. They spread quickly between the birds, and they cause devastating outbreaks where the birds get very sick and they die quickly. And this doesn't go unnoticed. Then we have the low pathogenicity avian influenza viruses, and they have a much milder course, and they can cause mild disease or no noticeable disease at all. So this may go unnoticed. And usually you will only find this if you go out and sample birds that may look healthy. So some of these reports will reports about ALPAI will result from active sampling of healthy looking poultry. So it depends on somebody wanting to find it, not just waiting for it to pop up. The issue with low pathogenicity avian influenza virus is that they can transform into high HPAI, and they easily do that when they enter a poultry flock, because when they transmit between birds, they can change. Even influenza viruses are very adaptable, and they will turn into this devastating disease instead. And that's why we're so worried about them. Influenza viruses circulate in wild bird populations everywhere, particularly the low pathogenicity avian influenza viruses, and in particular in waterfowl. But we expect to find influenza viruses in wild birds, and that's why they claim that you can't really be free from avian influenza, because if you have wild birds, you may have it and you can't control that. But when we're talking about freedom, we're talking about poultry, that is birds in captivity. There's also zoonotic potential to HPAI, and that's what causes the global fear. It can transmit to people, it can be a deadly disease in people, but it's not easy. These cases that we've seen have been after close contact with sick birds. It doesn't directly transmit between humans, but there's a fear that it may transform and turn into a global pandemic. So this is part of the issue. But I just want to state that this is serious enough, even if it's not a zoonosis. It's a really serious disease for birds and for their owners, consequently. What we mean by poultry, in the OIE code, they define poultry as birds in captivity that are kept for producing meat or eggs, or for breeding game birds to restock game birds populations. But the main species will be chicken, ducks, geese, turkeys. And then we have birds other than poultry that can be birds in captivity in zoo gardens and so on, or wild birds. Poultry production is very important for global food security as well as trade. This is a very rapidly increasing sector. It's becoming more and more intensified, and these intensive poultry production systems are very global and very complex. As an example, European chickens may eat feed that was grown in South America. We consume the breast meat in Europe, and the wings will be consumed in Africa, and the feet in Asia. So you can see there's obviously a lot of trade involved in this production chain. The global value of poultry production has been estimated to, in 2012, it was estimated to $200 billion US. This is from FAO statistics. I'm not sure how relevant that figure is right now, but at least to me that sounds like a lot of money. Also, the monogastric species such as poultry and pigs are very important for the future production of animal-derived protein for food, as they have less climate impact than the ruminant species. So there's a talk, in view of climate change, there's a talk about that we need to eat more meat from poultry and pigs instead of beef. So this is also an aspect of sustainability. When we look at what's reported outbreaks, that's just the tip of the iceberg. To the left, you have the reported low pathogenicity avian influenza viruses, and to the right, the highly pathogenic avian influenza outbreaks reported to the OIE since 2010. And I realize I'm confusing the picture because you have a lot in the US in this picture, but this is during a long time, and this is, as I said, is the LPAI is usually what people have either gone out to look for or stumbled over when they sample for other things, and the HPAI outbreaks will be severe and noticed. But what you don't see is what's not reported. What's reported is really there, but what you don't see is not reported, either because it wasn't detected due to lack of awareness or lack of diagnostics or lack of infrastructure for reporting. So this could be a resource issue as well. But there is a lot going on there that we don't see. And demonstrating freedom is really difficult. It's been touched upon that no country can really be free. Well, you cannot be free in wild birds. You can declare freedom in poultry, but this is really also very complex because poultry production systems vary so much around the world. And this is why the OIE Terrestrial Code states that there's considerable latitude available to member countries to provide a well-reasoned argument to prove that the absence of infection with avian influenza viruses, and that is assured at an acceptable level of confidence. So this doesn't really give you guidance on how to go about it. It just says that you have to know the local epidemiology and deal with it. And that can be really difficult for some countries, I realize that. The impact is huge of avian influenza. In short term, there will be a decrease in food supply or the supply of poultry products because birds die or are killed in control measures. There will also be a decrease in the demand of poultry products because loss of consumer confidence. Subsequently, as consumer confidence returns, there will still be an insufficient supply of poultry products and hence an increase in the prices. Those producers who recover quickly or weren't affected and maintain consumer confidence, they will benefit while the others will lose a lot. If there's this entire production is very dependent on breeding animals. So if there's a shortage of breeding animals because that sector is affected, there will be changes in trade patterns that may affect the risk of future outbreaks. Other sectors are also affected. Tourism, banks that have lent money to poultry producers that can no longer pay their loans. Other linked agricultural practices. For instance, in the Mekong Delta, rice production is very dependent on ducks for pest control. And if there are no ducks because they have died or are culled, pests will affect the rice production. The local aspects are obvious. There's a loss of work opportunities and income along the entire value chain. This involves feed producers, breeders, layer and broiler farmers, butchers, restaurants, food retailers, food industry, and all these people who are involved in producing poultry products. There will be a loss of food supply locally because birds have died, and also a lot of problems because of restrictions that prohibit the transporting or the movement of animals and animal products. And the long-term impact is quite difficult to determine because there are other things at play here. So there's been efforts to determine that, but it's really hard to separate what is due to the avian influenza and to other things. I found this report that's an example of economic impact of HPA H5N1 that's still circulating in Southeast Asia. The World Bank did a report in 2004 where they calculated on 3 different scenarios, where the optimistic scenario resulted in a cost estimate of 0.3% of the gross domestic product, that at that time corresponding to $116 million. In the intermediate scenario, there was a relatively quick control, but still 3 months downtime in poultry production and some reduction in tourism, and the cost was estimated at 0.6% of GDP. In the pessimistic scenario, there was a 6 month loss of poultry output and a decline in tourism comparable to SARS, and that's not totally unrealistic. The cost estimate would be 0.9% of GDP. And this didn't include the cost, the loss of capital due to culling of birds. So the impact depends on timely control, but it also depends very much on the structure of the poultry industry and how linked that is to international trade. The actual drop in 2005 in poultry meat prices was about 50 to 60%. When Vietnam suffered a severe outbreak of this type of avian influenza between 2004 and 2006. And they had a very strong control policy. The supply was reduced by 50%. But as you can see, there was also some people who gained from this because the price went up in the supermarkets that could retain consumer confidence. So people would still buy poultry meat in the supermarkets, but not in the other markets. And in this outbreak, Vietnam killed more than 50 million birds, and that doesn't include backyard poultry. So this was a severe outbreak. Just to round off, I hope I'm still within time, I want to talk about compartments. Because we've talked about regionalization, country freedom, and so on. It is very difficult. Commercial poultry holdings can be certified, and you can have checks, and you can probably convince your trading partners that these are free. But if you wanted to apply this to an entire region where you have a lot of smallholders with backyard poultry, that will be nearly impossible because the infection will still circulate in wild birds. And there are various influenza viruses circulating by wild birds. You can never make sure that nothing enters in this type of production systems. You have to separate the poultry from the wild birds, and that can be really difficult. Commodities are always safer. Live animals can be infected early in the infection. You cannot detect the infection. They don't show any symptoms, and they will multiply the infectious agent. The commodities that you take, if the animals were healthy when they were slaughtered, it's always safer. Even if there's something in there, you can deal with it. That you can treat the products somehow. There are guidelines for that. So it's always safer to trade in commodities than live birds. Biosecurity barriers are possible, and you can have compartments. And compartments mean that you can have one or more establishments with animals that are kept under strict biosecurity, so they are protected from this particular disease, in this case AI. And you would also need to have a monitoring going on so you can ensure that you would detect early on any incursion of the infectious agent. So this is quite possible. It's more or less a certification issue in the larger commercial production system. You need to do risk mitigation, work with early detection and risk-based surveillance. And this all presumes that you know the local epidemiology of the disease, and this is something that you need to start with. I'm a scientist, of course I think this is important, but otherwise you cannot deal with the problem if you don't really know what the problem is. And I just want to round off by saying that control measures, we talk a lot about mass culling of birds, and that is a very useful tool to get rid. If you cull the infected animals, they will not multiply the infectious agent, they will not spread it. But it has to be linked to compensation to farmers, especially if you have smallholder systems where people are not compensated for the culling of their birds. This will be counterproductive. Of course, if you're dependent for your livelihood on your birds and you know somebody's going to come and kill them, you would sell them before they'd come. And this just produces a spread of the disease instead. So this is very important that we don't use the same tools in a blanket fashion everywhere, that we need to adapt it to the local situation, and this is particularly important in developing countries, I think. Thank you.
Thank you so much, Susanna. I'm as somebody who advises developing countries most of the time, I'm particularly grateful for those last remarks, because I think that the practicality of it is daunting, and it's even more so as we're dealing with products that are, in fact, classically those that are produced by people in very small units in many developing countries. But of course, there is, to some extent, an inherent challenge between the food security or food safety interests at the consumer end and the producer interests that are just exacerbated by these very, very practical factors. I was also intrigued by your reference to climate change. I was aware of the cows in Ethiopia being a big problem, but I wasn't aware. But that's probably just me not reading the right articles. That it is generally cows versus pork and poultry. So I will probably adapt my consumption patterns here. Finally, I like your slide that says demonstrating freedom, because that's what we see on TV these days very often in Greece. But of course, in this area, this is a very serious, in fact, in this case, often deadly serious matter to deal with. So thank you very much for those comments. Time for discussion. Time for more discussion. Of course, I will happily invite the panelists to comment on each other's interventions just as much as anyone else in the room. So breaking with usual practice, I will not invite the panelists first. I will open the floor and also introduce some comments that have been made online in the meantime. Please, you have the floor if you want to. Any question, comment? I still have my question, which is the question that I asked in the middle. How relevant is this relationship between the big principle in Article 2.2, which says SPS measures need to be based on science, and the more specific articles on risk assessment that somehow related to this big principle. But when we have a situation where the appellate body or where the outcome is that I violate 5.1 and 5.2, but I'm somehow off the hook for 2.2, the question is, what difference does it make? I'm still not sure whether it makes a difference in real life, other than for the time that we as lawyers spend on it. That, however, is a question that has been commented upon, which of course you're still welcome to come back to it. If I don't have any questions from the floor here, then I will go back to go to a question that has been raised online. This comes from James Nidumpara. I hope I have pronounced that correctly. And says, if the member countries have a dispute with regard to the meaning of text of an international standard, what is the best way to discern its meaning? Given the wording of Articles 3.1 and 3.2 and Annex A of the SPS agreement, is not recourse to the Vienna Convention on the Law of Treaties the only unavoidable option? That's a question to our lawyers. So, please, by all means, who wants to get started? Alessandra looks motivated, so I start with her. Eugenia, you're of course welcome to.
Yeah, no, I mean, I just, so this was what India argued, basically. Let's use the Vienna Convention. And that goes back to what I was saying. What is the nature of these standards in the first place? Because they are not international treaty, they are, well, standards. So I think this is, again, it's a combination of law and politics, because one could try to give a very legalistic answer. Obviously, the appellate body has given its own answer, that it does not need to be the Vienna Convention, fine. But to me, it's very much of an open question whether it is desirable that is the group of experts that provide the the interpretation and why I have some concerns. I do not have an answer. I have just an invitation for more thinking about this issue. So these bodies are extremely important because, as we have just heard, we as lawyers, we don't get the picture. There are the scientists that help do the standards, but we all know that also the creation of standards is the result of negotiated processes between government, scientists, to also protect certain interests vis-à-vis others. In other words, the science that is then supporting the standards, or let's say being used as basis of the standard, is not neutral. It depends what we choose as a yardstick. So if we invite the experts of the standard body, that's it will provide a certain vision, and in that sense, I think it discourages plurality. So it's my concern. Linking more to the legal world, I think it might be helpful also to think of a different situation, but which brings is insightful in this case. In continued suspension, the appellate body, when judging on the independence of experts, say that the scientists, member of the codex body that issued the standard, were not independent. Now, this is a different context, so I don't want to make too much of a translation. But in order to say that they were not independent, that means that they took a vision of science, again, mostly maybe from sociology of science, where science is not just neutral, that you have a certain vision on certain problems. So you know that expects that you would come up with certain answers. Now, this is a slightly different issue because it's about the interpretation of a standard. So it's in this limbo between science and law. And that's why I think that if maybe the Vienna Convention might be overstretching the legal text, also the other approach where it's just the experts of that body might imply a lack of plurality, in particular when there are two countries that are clearly having opposite vision on the standards and where the interpretation of the standard is so decisive. So, but I'm interested in hearing Susanna on this because she might have a very different view.
Yeah, me too, actually, Susanna. So we're talking about you guys in a way. The lawyers have this fundamental problem. On the one hand, they'd like to think of this as something you can just basically ask someone who knows, and then that's somehow neutral. But of course, that can't really be the case, as exposed by Alessandra now, and also with reference to what the appellate body has already said at previous occasions. How do you see the interplay between the science? You made the difference between the standards as a hybrid and the law here. How does it look from your side?
I think this is a constant problem that, I mean, nobody is really objective and independent. We're people and we come from a certain background and we bring this into whatever we do, even in science, even if we're trying to be as objective as possible. So that's why natural sciences are very sort of strict in how we publish and how we do our investigations and how we do experiments and everything to ensure as far as possible that we don't bring too much of our human nature into our interpretation, and it's also subject to expert reviews and so on. But that said, we can never sort of be totally objective, and I think the problem with experts, especially in the veterinary field, is that it's not such a large field. And the OIE employs experts from all over the world, and they are linked. They are in their own institutions, but they are linked to the OIE, and the OIE makes use of them to make a good standard. But then again, these experts have already sort of formed their view in this standard, as you say. So it's difficult to find somebody who's a good expert and who hasn't already been working with the OIE, because that doesn't mean that they're bought by the OIE or that they are sort of corrupt or anything. It's just human nature. If you've already worked through a document and you've done a lot of debate around it, and you've come to the conclusion that this is the best way of putting this standard, then of course you will be stuck with that view. It's quite difficult to suddenly move very far away from it, although we're used to, as scientists also, to sort of test our conclusions all the time. So what we did yesterday or what we did last year can suddenly prove totally wrong the next year because we've learned and we've moved on. So we're also used to that. So we're used to having second thoughts about everything. But I think it's difficult to find a totally independent expert that would sort of be, if this person was so independent that they were new to the OIE code, then they wouldn't understand the OIE code.
Exactly.
So it's a catch-22 somehow, because these people are usually already involved. I think they will still be able to take as an objective position as is humanly possible, but it does take a lot of people. And also when you work with policymakers, it's a difficult thing because we want to be independent, but you also need to understand policy to answer the right questions. So there's again, with policymaking, there's a big sort of interlinking between science and policy, and how should that happen? Because we need to understand each other to have an effective communication, but we don't want to move into each other's zone, so to say. So these barriers, these boundaries are really difficult.
Yes, please, go ahead. Maybe if you can introduce yourselves as well.
My name is Vitaly Pogoretsky. I'm counsel at the Advisory Center on WTO law. My question really relates to Hannes' question on the relationship between 5.1 and 5.2 on the one hand and 2.2 on the other hand. And I see that there are three different requirements in Article 2.2. Under Article 2.2, members must, of course, ensure that their measures applied are based on science, but also members have to ensure that their measures are applied only to the extent necessary to protect health, for example, animal, human health, and also are not maintained without sufficient evidence. Does the fact that there are these three different requirements, in my view, in Article 2.2, does this fact affect the appellate body's ruling or statement that measures which, for example, violate Article 5.1 and 5.2 may not necessarily violate also Article 2.2 because there could be these two other additional elements in Article 2.2? And can you also elaborate on the relationship between 5.1 and 5.2, which really refer to measures which are based on science, and all these different three requirements in Article 2.2? I would like to know your views on that. Thank you.
Are you tempted, Alessandra? Eugenia? You want to go first, Eugenia? Or would you?
No, go ahead and I'll chip in.
Okay.
Okay.
Please go ahead.
Let me first try to see whether I understood your question correctly, because so you are again asking a clarification on this relationship, but you ask us. Well, actually, yes. Now that I rethink, I realize I didn't note because I'm immediately excited about this relationship. Okay, what is let's say the residual role of 2.2? I think you can see in two ways. In the past, there was a residual role because not the first time. In the past, it was said, I think in the easy hormones as well, that it could be that you violate 5.1. Not that you don't violate 5.1, but maybe you do violate 5.2. So it is a residual category that would make the net of the SPS agreement even more stringent on member imposing the SPS agreement. So in that sense, it's a residual role that impose another burden. So, well, there were some other science that actually tell that you are not basing your measure on science. That's how the appellate body interpreted in the past, even if I think it's gone unnoticed, but I will come back with the paragraph if you need it. Now what happened, they have created another residual category. That is, you violate 5.1, but still you do not violate 5.2. So it's one that, in a sense, it seems to expand the margin of a variety of SPS measure and of the science that the degree of science that can be used. What does that mean in practice? Well, I think that one of the problems with just relying on 5.1 is that sometimes it's too of a strict frame. So let's also see historically where does risk assessment come from. It's an Anglo-Saxon practice. I think I overheard, this is webcast, I shouldn't say, but I overheard someone that was loosely related to the negotiator, so don't, maybe it's, I was mistaken, but that was saying we didn't have a clue what risk assessment was when we were negotiating the SPS agreement. So, I mean, it's a practice that has a very clear historical evolution in which it has been firstly endorsed in the US, where also the cost-benefit analysis in those times were being endorsed. So for some scholars, it has also been a practice used to kill some regulation, the famous, regulatory XR that would kill any regulation that would go to IMB. So this is the historical milieu where risk assessment is emerging. Now, this has been, of course, transformed here in the SPS agreement somewhat, but that's the origin. And I think it's important we are aware of origin and of categories. I remember when I was more of a law and economics professor or assistant professor that I was explaining to my students risk assessment. They were looking at me like, this woman is crazy. Why at the law faculty we have to study this? And I was saying, guys, this is the future. And this is the future because risk assessment now is by a process of a network regulation by the WTO has been spread. So in that sense, my hope is that to having a residual category would open up the space to critically rethink what can be the scientific justification of a measure. In other words, to also give voice to some voices that sometimes are marginalized in an institutional process by which the depoliticization of risk regulation kills certain measure in the beginning. This doesn't, this is general, it's not about avian influenza. As you have noticed, I was very careful in being more attached to the legal interpretation than to making any assessment on the Indian measure. Why? Because before doing that, I really would like to understand more the factuals. And I should say, by looking at the appellate body and the panel report, I tend to think that there is something that could be discriminatory there. But before judging that, I would like to study more. And what is interesting is that sometimes if you go through this, 300 pages in total, how much of this factual you see is very little. So if they don't engage very much with the science. Yes, there is something, LPI, HPI. You start by really having the India as the guilt party because there is HPI, the high spread, they are full of it. They don't have the low one because they don't detect. So after the first page, you immediately see the picture. But actually, in the details, it's more complex. So, well, I stop here.
Thank you so much, Alessandra. Jenny, do you want to add anything?
Nothing, thanks.
Okay, Teresa, you have the floor.
Thank you, Hannes. Teresa Carpenter from the Graduate Institute. Thank you for having organised this, and thank you to all the panellists. I've learned a lot. My question actually is a little bit related to what the last speaker was just saying. I was wondering if you could help me understand this Indian measure in terms of its timing and what else was going on at the time. For example, was there a surge of imports immediately before the measure, or was there an outbreak of diseases in other places of the world? And I was just trying to understand the economics behind the dispute. Was there, for example, I can understand the complainant would have a strong motivation to want to keep a market open, or were there exports before that? Or is there a suspicion that there was meant to be some protectionist effect of the measure? Or were Indian consumers obliged to forego food that they would otherwise like to have imported, either because of an overzealous government or because of a very protective government? Anyone who could shed light on that so that I could understand it, I'd be very grateful.
Thanks a lot, Teresa. Anyone would like to comment on that? I'm personally not aware of the specific economic and trade context. That's the one you're referring to. of this measure? Is anyone? Is anyone here who knows but does not want to comment? Could be the case. Could be the case. Of course, Teresa's question goes to the point, why are we discussing this in the World Trade Organization's context? In this case, also physically in the WTO building, if there is no trade policy angle here, or is there one? No? Okay, I think we have to leave it as a question. Or Alessandra, you're welcome.
No, it's I also leave it as a question, and actually it's also some of the questions that I had that are on my head to investigate further. What I wanted to add is that when looking at the question of regionalization, I was trying to find whether there was some communication there from the US, for instance, to ask India to acknowledge these areas, and I couldn't find any. I should say, so in the past, there is a number of cases, for instance, of when avian influenza was an issue, and where in the negotiation between countries, this was solved. Now, I don't know if I find the example. I think it's somewhere here, but so anyway, there have been countries that bilaterally have solved the issue. I did look, because in theory, under this decision of the SPS committee, you should report, and maybe my look was cursory, but I couldn't see any of this interrelation between India and the US. And again, if someone on the floor knows better, I would love to hear.
It is my understanding that the trade interest is significant, but indeed, I think this is also behind this slightly opaque, Alessandra was very explicit about that, relationship between, on the one hand, the obligation of the exporting member to show its case under, its regionalization case under Article 6.3 of the SPS agreement, saying, listen, here, I have disease-free areas, and here's my proof. And on the other hand, the general obligation of the importing country to recognize and make an effort to look into disease and pest-free areas in its own right, on its own initiative when it takes the measure. Sort of this obligation to engage before a measure is taken is, of course, an old challenge of trade law. And it's been explored, you remember shrimp, turtle, and so on and so forth. Question is, how much do we have to talk before we can take measures? Especially in the area of SPS, the sensitivities are the highest, logically, especially when it comes to the real people in the real world, where they live and work and die and have fun as well. So I think that's the undertone that I suspect, that's my own speculation, has informed this ruling. That says, well, you also have to do your part. Yeah. You can't just sit back and then relax, and then when things happen, then complain. You have to engage as well. Yeah,
so for example, the thing is the one of Chile in 2002 in its relation with the European Commission, and the European Commission, after Chile, after the Chilean authorities presented sufficient evidence, has adopted a decision in October 2002. To allow for temporary regionalization of Chile for the purposes of imports. So, and there are also other cases, but of course that's maybe more when it's a huge outbreak. In this case, we are talking of a country that has only the...
Yes, please.
Thanks. My name is Colette Van der Ven. I'm a trade attorney at Sidley Austin, focused on WTO litigation. I wanted to focus on something that you, Alessandra, mentioned in your remarks, and that you also, Hannes, just referred to. You mentioned that the AB wasn't quite clear on what the role was of the exporting country under 6.3, the regionalization measures. And I was wondering if there was a way we could make sense of what the appellate body had said by differentiating the carve-out in a way of 6.3 as a de jure versus a de facto situation. So In other words, I read the dispute. Oh, sure.
Because I don't hear very well.
You have this
Sure. Is this better?
Okay, okay, there is also something.
Yes.
Technology. Okay, yeah.
So on the one hand, the AB has said that 6.3 is not a prerequisite, or the exporting country hasn't first to show 6.3 before a violation of 6.1 and 6.2 can be found. Yet what you quoted as well in your presentation is there is a carve-out there in situations where the exporting country has explicitly recognized for recognition of an ASF-free or low past prevalence area. And in this case in India, that carve-out doesn't apply because we're dealing with the juror situation. It is a law in the books that is challenged on its face, and as such, we don't get to the explicit request to recognize disease-free areas. So I was wondering if we could make sense of a bit of the ambiguity that you mentioned by saying that perhaps the carve-out applies to the jure challenges, the measures on their face when we don't get to specific recognition of disease-free areas, and the carve-out applies to where members do recognize disease-free areas. And if we distinguish, therefore, de jure and de facto, we may actually be able to categorize the AB's ruling with respect to Article 6.3 a little bit more clearly. I was just wondering on your comments on that. Thanks.
Would you like to comment? Eugenia, you're welcome to jump in as well.
Thanks.
So,
Yeah, if you want to start,
course,
I think I've been monopolizing. So
was your...
So actually, so you're asking whether this is de jure and de facto. I do see more just as the appellate body being careful as it is done in the past, and I'm also critical, but always very appreciative of the appellate body that has this huge, difficult task of carefully crafting its rulings. And in this case, I think it's quite clever what they do, because they are saying, well, you cannot just get away without doing nothing, but if you would just have some mechanism, then yes, then it's up on the exporting member. So in that case, let's say that the fix here could be not too dramatic, even though, again, it's easier said than done, because it's still a legal system of developing countries. I don't know how easy it would be to pass an administrative measure that just generally says that they would recognize these areas on which conditions. That might be also costly for them just to do that. But the way I see it is it's really trying to strike a compromise. And I think that's quite wise, especially when you are assessing a rule for the first time, so that you try not to be too draconian, for instance, if they would have just... and I think it's also faithful to the text, because there is something in 6.1 that it's a general obligation. So I'm not sure I see as more of a de jure de facto dichotomy. I don't know if that answers your question. Yeah.
thank you very much. There is a little bit more online. Let me bring that in. George, whatever his last name is, asks, at the end, the importing country in this dispute will need to comply with the findings of the panel and the appellate body, or in any dispute, really. For the regionalization obligation, the one we just discussed, although OIE code provides for specific criteria for regionalization, does the importing country have to adapt only those provided by OIE, or is it possible to comply with the SPS regionalization obligation by other means? What would be your interpretative answer to that?
Let me see if I find it.
Susanna? Yes, please.
Before you go into the more technical aspects, the OIE code doesn't actually provide, in this particular chapter on avian influenza, it doesn't provide clear guidance on how to declare yourself free, which is, I think, part of the problem mainly for developing countries, because you need to have resources to do your own science and to build up a case that you are free and convince your trading partners, since there are no guidelines. There are for other diseases, but not for this one.
How come?
I think it's, as it says in the quotation I put, it is very complex, and they can't really create guidelines that will be applicable in all different poultry production systems. So they have so far refrained from doing that. And I think that might be coming in the future, but the OIE code is something that has to be agreed upon by all the members of the OIE, and apparently they haven't been able to agree on something here. And it's really difficult to provide standards that covers so many different systems. So they basically say you have to know your own situation and deal with it and try to make sense of it. And that is resource demanding, I think. I think it puts a lot of responsibility and sort of you need to have a lot of insight in your own situation that is probably not available to everybody. So it's really difficult for some countries to do this. For rich countries with lots of scientists and so on, it's no problem. You can easily provide this certification of freedom for various parts of your country, but not for the developing countries.
Thank you. Virginia?
Yeah, my understanding is that the regional guidelines the guidelines developed by international standard setting organization can be taken into consideration when implementing the obligation of regionalization, but they are not the sole guidelines. In fact, in this case, there is none. Article 6.1, for example, clarifies directly that in assessing the SPS characteristic of a region, members shall take into account inter alia, so as among the factors, appropriate criteria or guidelines which may be developed by the relevant international organization. So I don't see that there is always a relevant organization, international organization that has developed guidelines for purposes of regionalization. In any case, it wouldn't be one of the factors that has to be taken into consideration exclusively. I mean, it's among the factors that shall be taken into consideration, not the sole one. And I see that my interpretation of this provision is that members are free, within the boundaries, of course, of Article 6, to implement regionalization according to their own systems, and taking into account into consideration also guidelines developed, but not exclusively, and when they're there.
Okay.
Could I,
Yes, please.
yeah. So again, I mean, here there is no real international standards, which means India would be quite free. I think there are some insights from the decision of the SPS committee on that, where mostly the type of indication that is given in this decision, the decision are of procedural nature. So about transparency in all aspects of the recognition process. And as far as I understood also, it was again a complex negotiating process to get to this decision, and the moment that the text was there, some members were unhappy. So it doesn't actually give too much guidance, which means there is more discretion in deciding how to frame this mechanism. But it was a compromise. So some members say, let's just go ahead with that because this is a basis. Again, what is interesting here is that we are a little bit in a reverse position of what the debate is usually framed, because usually there is the developing countries that has problem to export with this this type of goods, whereas here is the opposite. In this case, what would mean for India, it means that maybe just having some general mechanism would be fine. But then again, we have the WTO judicial system that is open-ended, so we will never know until there is a next case or a continued suspension for the Indian avian influenza.
Do I hear some critique there?
No.
It was stressed before that that the word case by case, or the phrase case by case, also appears in this ruling, as it does, I think, in most rulings these days. Yes, please, Colette, if you like.
Sorry, I just wanted to follow up on something that Suzanne mentioned. You said that there is no reference with respect to regionalization in Chapter 10 for, I believe, the Avian Influenza one. How about Chapter 4.3 that sets out OIE Terrestrial Code more general regionalization obligations? In what way are those relevant in assessing regionalization in the context of avian influenza and in the context of Chapter 10.4, which does reference to disease-free zones and compartments, I believe? Could you elaborate on that? Thanks.
Yes, thanks. Thank you. I just realized that I was a bit sloppy when I expressed this, because of course there are guidelines, but they are not very easily adapted to the local situation. So they're not. There are guidelines on surveillance in general, and how you have to have your authorities set up to make sure that you have a reporting system and so on. So there's a lot in the OIE code on which to build this. That you can use for your regionalization. Also, the general parts where they explain the entire authorities and the entire veterinary system, and also general guidelines on surveillance and reporting systems and so on. And in this chapter on avian influenza, there is instructions on how the laboratory capacity you have to have and so on. But you still remain with the fact that if you don't know where your poultry are, you will have difficulties applying this. And it doesn't say you have to calculate it this way or that way. It says you have to know your own risks and do a risk-based sort of evaluation on how to do it, on how to do your surveillance and how to ensure that things are reported and so on. And there is a lot of interpretation in here, and you need a lot of expertise to be able to apply it. So that's why I think it's really difficult for developing countries to do this. Even if they could do it, they could have free compartments at least for their intensive poultry production and use these guidelines. But you still need a lot of knowledge and a lot of help, I think, to apply this code.
I'm intrigued by the phrase that you just mentioned. There is a lot of interpretation in here. And I think if I take something home from today's session, it certainly includes that. It's not entirely surprising, but I think it is worth stressing very much, as you did, that even sort of the seeming any concept that leads to any kind of application of general rules to a specific situation is in itself an act that presupposes interpretation, if not is an act of interpretation. Lawyers like this distinction between interpretation and application, and I'm not entirely sure that that is so clear. We had a question. We had three questions. There were comments from Ashish Chandra, which we, I believe, addressed related to 2.2 versus 5.1 and 5.2. And on the other hand, the risk of divergent interpretations when we use basically experts as the interpreters, as opposed to the Vienna Convention on the Law of Treaties, meaning the panel as the interpreter, or both. I think that was referred to. And there was finally a question online from Sarah, who mentions that the OIE code is annually updated and negotiated by technical experts who might not serve as trade officers. I would suspect that they almost never serve as trade officers. And ask the question, if there is an apparent conflict or discrepancy between what is provided in the SPS agreement vis-à-vis the OIE terrestrial code, which one should prevail? That goes to the same issue as we had discussed.
There is a conflict between the OIE?
Between the OIE code and the SPS agreement. Well, most of the times there won't necessarily be a conflict, but there could be one when you come to certain substantive provisions in the SPS agreement. Which one would prevail? I guess the short answer is the SPS agreement, because this is the WTO. But please, go ahead.
Perhaps it's possible that the panel appellate body will find a way to reconcile the provisions, because that's also what always often happens. And there's also the issue of multilaterality, which I think it's important also in the context of the expertise. OIE standards are decided by negotiation or a process of a negotiation, and the WTO is also a process of negotiations. The rules have been agreed by countries. This type of conflict or questions is quite common in the context of interlinkages between trade provisions and environmental provisions. And there I see that the trend is always to try to highlight the complementarity of the two systems and the way they actually work together. And I mean, in shrimp littoral, you have mentioned the Appellate Body remarked on the preamble of the WTO agreement and the Rio Declaration. So I'm not aware of whether it's a conflict like this. I suspect not, but maybe I stand to be corrected. Where a conflict between OIE guidelines or any other international relevant standard setting organization for the purposes of the SPO and WTO rules have a conflict has ever arose in the context of disputes, but my view would be that the panels and Appellate Body will probably find a way to reconcile the possible potential conflict in the two sets of law.
I believe I would share that sociological guess, but please.
Even legally, to me, it's difficult to conceive of a conflict because the SPS is sort of a meta-regulation compared to the standards. It embeds the international standards within its frame, and which means they really deal with different things in a sense. Of course, they all deal with trade, but the SPS agreement offers a frame, and then it doesn't tell what is good and what is bad. The standard does. So that's a little bit the down to earth. So it's hard to conceive of, in terms of framing, of a conflict between the two for me.
Yeah, maybe to this I would also like to add that, in fact, the complementarity already existed as much as international standards in the context of SPS are, the use of them are a tool for trade, harmonization of trade measures. So, in fact, there is already embedded a sort of complementarity. I too share the view that potential issues of conflict are a bit difficult to imagine.
Well, thank you very much. I am not so sure. I don't think I fully agree with you. I think it's quite easy for rules when it comes to procedures, for example, to come to a point where there is some descriptions of what the SPS agreement wants members to do, and then what other international instruments want members to do in the same situation. So I wouldn't rule that out. In theory, yes. In theory, there is this SPS or TBT refer to international standards, and that's how the interface works. I think in practice, when you look into details, it might well happen, and at that point, that question would arise. But I share your assessment. I think they would find a way, rightly so, to come to a joint interpretation. I want to come back to one point that I think Susanna quite strongly made, which is that in the end, while no one is independent, a scientist, when asked to make an assessment, would probably be scientist enough to be self-critical at that very moment, even if he or she was part of the standard generation a year before. I agree with that, although I have to say in a dispute that I had some little role to play recently in the SEALS case, we saw some quite divergent views of scientists that were had clearly to do also with base beliefs that people had in climate change. That's particularly pronounced, and I know you agree. I just wanted to compliment this. I think that's what you said. People do come from their individual backgrounds and assumptions. If there are no further questions from the floor, I would invite the panelists to perhaps offer their concluding comments, if they have any, and we would leave it at that. you want to start, Susanna?
I have some questions for Susanna.
Yes. Oh, please go ahead. We still have a minute.
Okay, I would like just to have your view on, and maybe you can pick, because I would say that the first point is not so relevant. So the argument of India that L9 is exotic, it seems already that you dismiss because it's just a question of surveillance. I don't know, but I just would have liked to have your view on that. The other is the surveillance is also something that has been criticized to India. What is the feasibility for India to have a better surveillance system? And the last point is the argument of India that it is different when they have to contain an outbreak of a domestic nature vis-a-vis one that is with an imported product. So just really like the dispassionate factual analysis of these 3 points.
Well, those were quite difficult questions. Well, yes, I think they can. Well, if we start with the freedom from LPAA, no, I don't think India is free from that in wild birds anyway. But that's not the issue. You don't have to be free in wild birds. I looked at the number of samples they'd taken, and they say they didn't find anything, but you need to take an enormous amount of samples to say that you don't have anything. You can take a subset of samples and find something, and then you found it. But to prove that you don't have it is a much harder work, and it's much more resource demanding, and it's not worth it because wild birds travel around with things, so that would just be a snapshot in time, so it's not really worth it. I think it's not up to me to say what India should do, obviously, but I think an option would be to look at compartmentalization and look at what in the commercial poultry production to try and have free compartments. If you want to have some sort of declaring of freedom. And so you take what you can protect and you protect that from the disease. And then you work your way from there until you can protect more and more of the poultry production systems. But you start with the easy thing, I think, and then you have a lot of value in that. Surveillance is difficult, and you have to decide what do you want with surveillance, what do you want to prove, do you want to find things, do you want to have an early warning system or what, and you have to design it differently depending on it, whether you just want to monitor what's going on and establish that the trend is not changing, or if you want to detect things early, or if you want to prove freedom and so on. So this is a big issue. I mean, this is a big scientific exercise to design a surveillance system, and it will be resource demanding. But there's a big thing now going on in surveillance discussions that you have to do risk-based surveillance. So you look at where your risks are and you do surveillance in those areas, so you can target things, and that will be more cost-effective. I think they have a point in that there is a difference in things that come from the outside and things that you already have in your country. My first reaction is if you already have a disease, you can't really argue that you don't want it coming into your country because you already have it. But these are different strains, and they could be entering at different points. So it could be a problem if you know where your risks are in the country, and then you import things. They create new risk and new patterns, so it could emerge in new places. So there is a point, even if I don't think it's valid enough in this particular issue. Well, it's not up to me to to say that, but obviously nobody thought it was valid enough in this issue. But you could argue that still, that the things that come from via other routes are different. And then I can't remember, was there anything?
Yeah, so the other point is that they say, well, for us it's easier to contain if the outbreak it's where we know, like our domestic product, or if it's so it's contiguous to what you are saying.
Yeah, it's like, but that's just the thing with dealing with infectious diseases. I've talked to people who deal in bioterror about this. They say that if something is unexpected, you should suspect bioterror. But everything is unexpected. You don't. If you knew where it was going to happen, there wouldn't ever be an outbreak. So there will always be. I mean, you expect the unexpected. So yes, there would be new routes of introduction if it comes via imports, but you still, I mean, they would still be surprised by whatever happens. So. But I think India can do better with surveillance without so much more resources, but they probably need to rethink their entire surveillance. And why do they need it? That's the main reason. I mean, you need to know why you want to spend these resources before you spend them.
Expect the unexpected. That is what we have to do. I think this ties in with the question that we've received by Twitter, namely on risk assessment and the importance of import risk analyses, as referred to in the OIE code. I'm not an expert on the OIE code, but the question here is, please provide the relevance of import risk analysis in the OIE code as applicable to this dispute. And a question before that was, please provide the comment on the importance of risk assessment and negotiations before taking SPS measures impacting trade. Does anyone on the panel want to refer to that? Respond to that?
Right.
Yes, please.
Well, if India wanted to do a risk assessment according to the OIE code on the risk of imports of avian influenza, they could have done that. But that, again, to make that risk assessment transparent and sort of reliable for everybody, that would be very resource demanding. So I think, again, we come back to the developing countries being sort of at a disadvantage in these issues. And as you mentioned, this is a sort of Anglo-Saxon practice, and we have a lot of people skilled in risk assessment in some countries, and in others we don't. But it would have been quite possible to make a risk assessment on this issue, according to the guidelines in the OIE code.
Well, we started with closing words. Susanna, I will invite you again, if that were not your closing words, to give us some.
Well, I would just like to thank you very much for having me here. I've learned a lot. I've learned that trade law is not black and white and open to interpretation and applicability and so on. I think this is a very interesting case. At first it looked, also from a scientific point of view, it looked quite clear-cut, and then when you start reading, it's not so clear-cut. So there's always issues in there. There's layers beyond layers when you start reading about something and we start talking about something. So I've learned a lot from this discussion, and thank you very much.
Thanks. Eugenia.
I share Susanna's view on this learning process, really. I was tasked with the role of giving an overview of the case, and I've also, like Susanna, I thought the case was a little bit more clear-cut than in fact it turns out. And I thank you very much, Alessandra, for the insights on the relationship between Article 2.2 and Article 5. We share an interest there, yeah, I mean, again, thank you very much for listening to me and for the participation.
Thank you so much, Alessandra.
Well, thanks to all of you and for the organizer. I've also learned a lot, but mostly I realized I have to learn even more about this case to really have some meaningful thoughts. I think this case brings to the front the role of developing country under the SPS agreement, which probably is an agreement that has been framed not with that in mind. So in that sense, I think it raises important legal, political questions. There was a question lingering in my mind, but I didn't dare to formulate, but I think it's something everybody of us can think, whether this additional risk from imports can be evaluated. It sounds like an heresy, especially said in the WTO, because it's really a risk from trade in the end. But I think it's worth thinking, especially when the country is developing countries. And finally, I'm very glad that we touched upon how science is constructed. I'm working on the relationship between science and technology studies and international law, so I invite everybody to start to read some of this literature. And again, thanks to all of you. I really enjoyed this event a lot.
Thank you so much. Indeed, we learned today that the terrestrial code also applies in subterranean conference rooms. That's good. And that human intelligence can still debate complex questions, not just AI. That's also not too bad. I think leaving us here on this notion of this lingering question that one is not really allowed to ask too loudly, which is, what about the risks that specifically have to do with trade? From a practical perspective, practical policy perspective, it is often simply easier to watch borders than anything else, backyards in particular. So if you can already contain the borders, that may, from a public health or pest control, disease control perspective, may make you feel a lot more comfortable, even if you know that you have more homework to do at home. But trade law does really not like this type of discourse. So we have to be careful about it, for good reason as well. So we have to be careful about this. This is one of the many interfaces that we have to deal with in the future. But I share, in the end, Eugenia's assessment that all things considered, the panels and the appellate body are certainly trying very hard to find the ground on which the next step can stand, if not the entire future, looking at the case-by-case perspective. And it is my feeling that they tried so quite honestly in this case as well. Well, thank you very much. Let me conclude by saying again thanks to Finland for helping making this possible. I want to issue a personal word of thanks to Yashwan at ICTSD and the entire team at ICTSD for providing such a great basis for what is happening. And finally, the feedback forms that you have in front of you are still of high interest to all of us. And very finally, thank you very much to the three panelists. We had a distinct Italian accent to my left, a Swedish accent to my right, and definitely a quite appropriate female accent on this panel. I think all panels should be composed with this gender balance. I think that would perhaps change things in this organization a little bit. Well, thank you very much for having been here. Thank you everyone who's been engaged online, and we hope to see you at the next Talking Disputes.